All right. Can everyone see that? The slide, whose copyright is it everyone anyway?
Yeah,
Great.
yeah.
All right.
I think that's working. Thank you. Um, but we did want to do a quick poll to get an idea of where everyone is with the topic of AI and copyright, and maybe what some of your concerns are. So we listed out some of the concerns, but you can also drop them in the chat if you have any additional ones. Wow. So yeah, I'm seeing a lot of where the training data comes from, how to cite, and who owns what's created. So I'm going to end it and share the results now. So we're going to cover these topics and a little bit more. Um, the next slide is a brief outline of what we're going to talk about today. So we've basically broken it into the ownership of what goes into AI and what comes out of AI. And so I'm going to talk about what goes into AI first. And we're going to jump right into the case scenario, the first one. Which this is something that we're actually expecting to see more of in the future. And that is a researcher writes a paper published in a subscription access journal that has a deal with a generative AI to use its publication as training data. And we want you to think about who owns the copyright in this scenario. So keep this in mind. We're going to give some background information, and then we'll come back and talk about the answer to this situation. Um, The next slide really gets to the heart of the matter because we're going to be talking about the training data. So training data are the large data sets that are used to teach AI models how to generate new content. There is not a lot of transparency about where training data comes from, but we know that there are a few different ways that companies are going about obtaining this data, and two of them are through deals with publishers and under the banner of fair use. So recently, some large publishers have started making deals with AI corporations to add their content into training data. So Wiley and Taylor and Francis are two of the larger publishers who have made these kinds of deals. Um, Wiley made a one-time deal of $23 million for access to all of their academic and professional books. So the authors of these books don't really have a say in the matter because most publishers require the authors to sign over their rights in a publication contract. So these include the right to reproduce their work and to create derivatives, like an AI summary would be a derivative of the original material. So another way that Gen AI gets training data is under the banner of fair use, or at least they hope it is. Fair use is something that we use all the time in education, but it's determined by four factors that I will not expand upon here because I could probably talk about them for another 30 minutes and I'm not going to bore you guys to tears with it. But the main point, the one that's most important in these situations, is that fair use is decided individually by a judge in a court of law. So as of December 2024, there are over 30 lawsuits that have been filed against different AI companies for copyright infringement. So it's going to be a long time before each of those lawsuits actually makes it in front of a judge, and we will know if it's fair use or not. So as of right now, we don't know, and it's going to be a while before we actually do have an answer. What we do know on the next slide is something that came out of one of the more well-known lawsuits, and that is of the New York Times against Microsoft. And actually, recently, I believe that the Daily Mail from the UK has joined this lawsuit with the New York Times against Microsoft. So this is the court opinion, and the judge states that this case is about whether defendant trained their large language models using plaintiff's copyrighted material and whether that use constitutes copyright infringement. It is not a referendum on the benefits of generative AI. So this likely means that the benefits of AI will not be weighed as one of the four factors of fair use in this case. So that could be really telling about the way that this case could end up going. But again, we're not going to know until it finally goes to trial and is decided by a judge. There is one other way that Gen AI gathers training data, and that is from its users. So our prompts are fed back into the AI to give existing training data more context and to teach it how to respond back to us better. So we have to be mindful not only of our personal information that we enter, but also of other people's copyrighted material, such as a PDF of an article that we would upload to get a summary. There is a new option with ChatGPT where you can turn off the feeding the beast mode. And there are other AI like I believe Microsoft Copilot with our subscription service has a situation where our information isn't being fed back into the training data. But again, there's not a lot of transparency with these AIs. They're all relatively new. So each of them has their own way of using our information, and we should really consider that whenever we put more information into them. So let's head back to that scenario from the beginning. In this case, the publisher owns the copyright through a publication contract, and they are free to make deals with AI corporations that exercise the rights that they are assigned. So this is why it is really critical to understand the publication contracts that you sign so that you know which rights you're giving away. And I will say that the deals that have been signed so far are for books. So we don't have any official word on journals unless I'm mistaken and something new has popped up. Um, but again, it's something that we're looking forward to seeing in the future, probably.
All right. So now that we have that great foundation of generative AI's training and input, let's go into the output of generative AI and who owns the copyright. So the second scenario we have here is a person with a disability used AI to assist them with writing a book. So in addition to just who owns the copyright to generative AI's output in general, we're essentially asking, does the reasoning or context for using AI affect whether or not a creator can gain copyright over an AI generated work? So this is just something to think about as we go along. I'll actually be going into a couple of different related examples as well as addressing this one at the end. So this is from the US Copyright Office, and it's important to note that copyright is granted to an original work, and they define an original work as works are original when they are independently created by a human author and have a minimal degree of creativity. Independent creation simply means that you create it yourself without copying. And this is our bolding here, but from this alone, it's pretty clear to see that AI cannot claim ownership over content created by it within current copyright law because it is not human, and copyright law mandates human authorship. So if we think of this in the pure sense of I put in some sort of prompt into ChatGPT and it creates an output, that output is not owned by ChatGPT. And this actually, this idea that a non-human entity can't own copyright is not without precedent. This is Naruto, and Naruto is a monkey where a photographer named David Slater set up a camera in the jungle, and Naruto came over and amazingly took a selfie of himself by pressing the button. And this is the selfie here. This photograph was on Wikipedia, I believe it was Wikipedia, when Slater tried to claim copyright over it. So he wasn't even trying to claim copyright for Naruto, he was actually trying to claim for himself. But the Copyright Office, or it was determined that Slater did not own the copyright because he did not take the picture. If we go back to that previous definition, and the importance of meaningful creation or output. Slater did not take the picture, so he did not have the copyright. But Naruto is not human and therefore also does not hold the copyright, which means this selfie is actually in the public domain. So this is an important precedent that's set for AI, as a similar representation that is worth considering. With all of this said, even though AI or animals can't hold copyright for their output, it actually can be plagiarized, though. So, um, plagiarism, we often think about that in terms of making sure there's appropriate attribution to the original creator, largely for copyright reasons, but it's also an issue of transparency and honesty in terms of not passing off your someone else's work or something else's work as your own. So if you try to take what AI outputted and claim that as your own, even though there's no copyright held on AI's output, it is still plagiarizing to pass it off as your own. And Microsoft has a good brief article on this, specifically about AI and plagiarism, where they say ultimately using AI to generate content and passing it off as your own is plagiarism. Since it is not your original work, it falls squarely into that category. Using any AI software to generate a final product will lead to the same academic misconduct as plagiarism. And I personally thought that note of academic misconduct was especially important to our context because I think we rightly examine AI issues, especially within teaching or within class, as an accuracy issue, and accuracy issues absolutely exist. And I'm sure our fellow librarians will talk about that and in some great detail in future presentations. Um, but it's not the only issue here, right? And it's plagiarism is also an important issue here. And it really, what this is really saying is that if I were to try to turn in an assignment that ChatGPT generated as my own, it's really not so different than if I had a classmate write an assignment for me and tried to pass that off as my own. And I think it's just really important that we understand it in a similar way, um, because, we really want as much academic integrity and honesty in our work as possible. With that said, that doesn't mean that you can't use generative AI in your research or writing or anything like that. You just have to cite it, just like anything else. And there are specific ways to cite generative AI. So our librarian, Heather Barichka, has a great guide on AI literacy, and part of that guide includes citing generative AI. So I pulled this citation from there, which I believe also comes from the APA 7 guide on citing ChatGPT. There are other citation styles in that guide. I chose this just for simplicity's sake. And I'd like to go through this just briefly on how this citation is working here. So that first spot where it says OpenAI is usually where the author goes. And OpenAI is listed as the author here in the sense that it is the creator of ChatGPT, not necessarily the author of what was said by ChatGPT, but the author of the tool. So that's why OpenAI is in the author slot. If you had used Copilot, you would, Microsoft or something like that would be the author. Then the date in the parentheses is the date of the model. So whenever the model was created, the model that you used for this, that would be the date that you would put in there, and you only need to put the year. You don't need to put like the exact date that that model came out. Um, Then the title, what's in the italices, is the title of the AI itself, the name of the tool. So in this case, it's ChatGPT. If it was Copilot, it would be Copilot, so on and so forth. Then this is a really interesting note. When I first looked at the March 14th version, I thought maybe that was saying like the day you used it. That's actually not what it is. Apparently, OpenAI marks its versions of ChatGPT based on dates. So this would be similar to if a different tool had like a 2.0 version or a 5.7 version or something. That's what's going in the parentheses right there, is the version of the AI that you used. And it just so happens that OpenAI marks versions by date. So that's what's in the parentheses, is the version
Okay.
of the AI tool. And I'm just checking really quick. Does somebody have a question? Okay. So then in the brackets, we have large language model here, and brackets are frequently seen in APA specifically for things like conference proceedings or personal conversations. Basically what we're getting at here is, first of all, differentiating this from OpenAI actually authoring something like a blog post about ChatGPT and differentiating that it's specifically something produced by the large language model rather than something they wrote themselves. But also this frequently indicates some kind of conversation that can't necessarily be directly referenced back to. So, a journal article, you can just go to that journal article because it's published somewhere and read it in that way. But that's not necessarily true for a lot of generative AI. What it produces tends to be unique and isn't repeated again. So like if you went and asked the same exact question, you might get a different response than a different researcher did. And so that's why it's important to note that it's this distinct conversation with the large language model. And then here it links directly to how to get to ChatGPT in general, not to the specific conversation. It is worth noting, though, that a lot of AI tools now will have the capability of linking to specific conversations you have with it. So generally, you need to select it as a feature. You need to go and like mark it as public and then get a unique URL for it. If you can do this, especially in a research capacity, that would be great so that people can refer back to the exact chat. Frequently, what researchers have been doing as well is saving a stable version of the chat in something like a PDF form and then using it as an appendices in the research paper itself. My personal thought on it is I recommend both if possible. Just one, because it's always good to be able to refer back to things, but also just in case for some reason the link becomes unstable in any way, that way you don't lose that data, but also because honestly getting there through the link can be kind of clunky. You might have to like log in, and then I've just had some personal issues with that. So it seems like it's up and coming to be able to refer back to these chats by link, and that exists, but if you can also save the chat and use it in appendices and then parenthetically cite it in the way that you would appendices in research, that's ideal as well. All right. So back to our scenario of who owns the copyright, and the person with the disability used AI to assist them with writing the book. Honestly, it depends on how much they contributed and what point they contributed to the creation. So I'm actually going to go over 3 examples here, again, that are all slightly related, but point to slightly different things in terms of generative AI's output and copyright. So the first example I have here is of a graphic novel created by Krish Kostanova called Zara of the Dawn. And Kostanova applied for copyright to this. And what they did essentially was they created the text, they wrote all the text themselves, and then they assembled this book, but used vigorous prompting through, I believe it was Midjourney, to do the artwork for this graphic novel. And the Copyright Office said, well, we will give you copyright to the text because you created that, and to the entire compilation of Zara of the Dawn, but we will not grant you copyright to the images themselves because you did not create those images, generative AI did. So what that essentially means is that if someone wanted to use the images, they would essentially be public domain, but not the text that they went with or like the entirety of the compilation. That was granted copyright. So it was a little bit of like some of it, not some of it. And another interesting case that's really relevant here was Thaler versus Perlmutter, where Dr. Stephen Thaler actually created a generative AI himself that could produce images and did so, created images with this AI that he created, and tried to apply for copyright to those images. And he was not granted copyright. Even though he had created the algorithm himself. And the Center for Art Law has a really nice brief post about this that's in the references. I'll just quote what they said here because I think it sums it up well, which is that the court declined to entertain the plaintiff's various ownership theories and stressed that the AI-generated image was never eligible for copyright protection. It acknowledged the complex questions posed by AI, but asserted that the case at hand was not as intricate. So it didn't even seem in this case that it was as complicated as something like Zara of the Dawn. And I personally think this is a really important precedent because although AI can't own its output and we can't own its output, no matter how we prompt it, the companies that have created the AI also cannot own this output, at least with this precedent. So this is really coming down to if generative AI created it, nobody owns it. So that brings us to the example that I gave earlier of what about a person with disabilities? That's exactly what AI Machinations is. A creator named Ellen Ray Shoup used generative AI in order to write a book and argued that because she used it for disability reasons, she should receive copyright under the Americans with Disabilities Act or the ADA. The Copyright Office, however, did not fully agree. There's a Wired article that is in the references that has this quote about it. They said the U.S. Copyright Office's notice granting Shoup copyright registration of her book does not recognize her as author of the whole text as is conventional for written works. Instead, she is considered the author of the selection, coordination, and arrangement of text generated by artificial intelligence. This means that no one can copy the book without permission, but the actual sentences and paragraphs themselves are not copyrighted and could theoretically be rearranged and republished as a different book. So this was a similar result to Zara of the Dawn, where the entire compilation was considered unique enough to assemble this together, but um, the pieces of it, in this case, the text, were not and could theoretically be used otherwise. And disability was not a factor in this. So I'm sure we'll see more cases like this. I've been following them out of my own research purposes, and I probably should state at this point, I'm not a lawyer. I'm a researcher interested in this sort of thing, so this does not constitute legal advice in any way, but this is the kind of precedent we're seeing in terms of creations. So these are the things to consider when you are creating your own research or work and using generative AI. With that said, as one final note, there is a difference between AI generated versus AI assisted, according to the Copyright Office. So while we've seen through these examples that AI generated work may not be copyrightable, AI assisted work might be. And the distinction here is what the starting point was. So one resource to the Copyright Office actually gave the example, gave a direct example of this. And that was, say a photographer took a picture and then used generative AI to edit the photograph. The photographer could apply for copyright status through that because they created the original picture. However, if someone prompted an AI to create a realistic photograph and then they edited that photograph by hand, they could not likely gain copyright over that because AI generated the original image. So essentially what this could mean for your research or any other work you do is that you'll want to be, if you feel so inclined to use AI, you'll want to be very mindful of which parts you created yourself. And the more you create yourself originally, the more likely you are to be able to claim and retain copyright over that versus if you started out with generative AI, which is less likely to be copyrightable because of where the original work came from, essentially. So just something to keep in mind. And then, of course, there's always citation to go with that as well. So I think that pretty much covers what we wanted to cover here, with, of course, your questions in mind. So if anybody has any questions about what we talked about or larger AI and copyright questions that perhaps we didn't cover, this is a great time to ask them. You can chat, you can unmute yourself, whatever you prefer.
I'm also putting in the chat the flyer for this and the other events that we're hosting this week. So in case you haven't registered for all of them, I've got QR codes there that will help you register. Heather says, do you think authors will start to demand different agreements with publishers to protect their copyright? Yes, I do. There's a tool that you can use as an author whenever you're going through the publishing contract deal with your publisher called an author's addendum. And that is a tool that you can use to outline the rights that you want to retain and the ones that you're willing to sign away as part of the publication deal. Unfortunately, as part of this process, a publisher can look at that addendum and say, no, we don't want to do that. And that doesn't mean that they won't publish it with you. It just means that they won't agree to your stipulations. So we don't have a whole lot of power as authors to retain our rights to the work that we publish. But I do see part of the addendums becoming like how AI can use their work in the future.
I'll take this next question. It looks like Christine asks, if you wrote a book and used generative AI to assist with editing, how would you be able to claim the work as your own? Again, I'm not a lawyer, but my understanding is it would depend on how much of the work was altered based on the editing and how much was meaningfully what you created versus what the AI edited. So, for example, Grammarly technically counts as an AI. And I think plenty of people use that, and it doesn't, um, Grammarly also has a generative AI component, but the component of it that does grammatical edits or like sentence structure, that kind of thing, the Copyright Office, it seems, would generally feel, or it could be argued that if it's not meaningfully edited in terms of substantial content, in terms of substantial original work, then that's why it would still be copyrightable, because the edits made by AI aren't substantially original. And that's where that second part of that definition really comes into play there. So that's, and it could be on a case by case basis. Again, it's not necessarily all or nothing. It's a matter of degree, it seems.
Okay, Tracy is continuing the conversation about publishers. If publishers determine they will not accept stipulations from the authors, what incentives do they have? What incentive, excuse me, do they claim an author has in still choosing to publish with them? Thinking also about how the work may become public domain once AI produces new ideas from it. That is a very strong point. And that is one of the reasons why I think currently we aren't seeing more deals being made, because people are pretty wary of the ones that are already existing. And we do have a resource in our references that we'll share that is tracking all of the current deals that have been made with these publications and publishers. Um, so there's not very much incentive to publish with them. And people might even start considering open access publications more strongly, because they're more transparent about providing the information openly to anyone. And so since open access publications are open, they are also part of training data. So they are getting pulled in by the AI, but at least the publishers are more transparent about exactly what's being released.
Yeah.
You're very welcome. Yeah, copyright is kind of my thing. If you have copyright questions, you can come to me. My information is ki.dorset@widener.edu, so I can help you with that. But yeah, and if you have any questions about this presentation, you can email either of us and we'll be happy to give you more resources and more information. Thanks. I'm going to go ahead and stop the recording now.